Hello, listeners. The opinions expressed by the participants in the following podcast are their own and do not necessarily represent those of their law firm, government agency, or other type of organization. We now cut to our program and hope you enjoy.
You're listening to Legal Talk Network.
Hello, and welcome to our podcast live with the ABA section of Antitrust Law. This is Kail Jethmalani, and I'm the Young Lawyer Representative for the Corporate Counseling Committee. I also have with me Liz Kraus and Krisztian Katona, both from the FTC Office of International Affairs. And today we're here to discuss recent developments in Latin American competition law. Joining me now, I have Alexandre Macedo, Pablo Trevisan, and Oscar Garcia. With that, I'd like to turn it over to Krisztian.
Welcome to the show. What we see today in Latin America is truly an antitrust revival. The last few years, we have seen a rapid acceleration in antitrust law and policy development and major institutional and procedural reforms in a number of Latin American countries. Today, we'll talk about some of these key developments and ongoing reforms. And as an added bonus, we'll hear about some consumer protection developments in the region as well. We'd like to hand the mic to each of our guests for a short introduction. First, to tell a little bit more about yourselves, where do you work and what you do. Perhaps Alexandre first.
Thank you, Krisztian. So my name is Alexandre. I work at CADE as a general superintendent. CADE is the antitrust authority in Brazil. I have been in CADE for the past 4 years. And CADE is a very independent institution, and we do cartels, mergers, and unilateral conducts.
I'm Pablo Trevisan, commissioner of the Antitrust Commission in Argentina for the last 3 years and a half. We're in a very transitional period in which sooner or later I will get no job because a new authority will be put in place.
Hello everyone, my name is Oscar Garcia. I am the administrator of ACODECO, that is the agency in charge of consumer protection and antitrust matters in the Republic of Panama. I've been there in the agency for the last 20 years, 4 of the last charge of administrator, that is some kind in other countries as a president.
Well, thank you so much for joining us. We're really excited to have you here today. I'd like to open the floor to our panelists to really start by providing our listeners with a quick overview into your priorities and a few key developments in competition law and maybe consumer protection law in your regions. And I would start again maybe with Alexandre for Brazil.
Thank you very much. So Brazil, just want to highlight, first of all, that Brazil just launched its peer review and we just got in as associate in OECD. So it was this week and March 25th. And this is one big thing for Brazil it's happening right now. But talking about CADE, if you look for the past 10 years, CADE was doing a lot of cartel works. So we're fighting against cartel. We're putting all our effort to fight cartels, and especially in public procurement. We also have, besides the leniency program, we also have a project that calls BRAIN that help us to find evidence against cartels, and we depend on our own. So this is one good thing. And what is BRAIN means? BRAIN means an algorithm. We have a huge big data of public procurement with the value of the bids for the past 20 years for each company and each bid. We have the name of the partners of the company, where they move to, the relation between companies. We have the information from the customs. We have a lot of things that you can put together, develop the algorithm, and see a very nice result to trying to figure out the standard and the behavior of each company and see if they are colluding or not. This is one important thing that is happening in Brazil right now. The other thing that is happening is after we develop this and I guess doing a good work in cartels, we decide to move to unilateral conducts. So in Brazil right now, we have to look at, especially to look at unilateral conduct, especially because of the digital economy. So we're seeing giant companies, tech companies, and this is a big deal in Brazil because we're facing some problems. Some people are complaining, and usually Brazil, because the structure of CADE, we was taking care much more about merger and acquisitions and cartel than unilateral conduct. But the past 2 years, these numbers rose a little bit, and we put in more effort to unilateral conduct.
Thank you so much. I know from the international community, the BRAIN project is actually cutting edge work that we're all interested in. And clearly we're all looking at the digital issues too. So more to come from CADE on that. But I'm going to turn to Pablo Trevisan now about what's going on in Argentina.
Thanks, Liz. And thanks for giving us the opportunity to be here. We've been also using our brains to get on a very transitional period in Argentina. As you know, and I don't want to be repeating here, but as you know, we have a new act since May last year. There were huge changes that are right now going on in Argentina as a consequence of this new act, that we can go further with that if you want later. And we have also decided on some important cases on the cartel side, on unilateral cases also, and we have also done quite a great job on reducing the time frame and improving the quantity and quality of cases on merger control. These months, and actually the timing of this podcast, I think it couldn't be better, because yesterday we just got the news of a new resolution that actually is the kickoff of the selection process of a new independent authority. That is the main change of the new law. So that's a process that will go on, and we hope to have a new authority in place, as I said, more independent and decentralized of the central government by September, October this year. So that's definitely the best news in Argentina. And on other issues, right now we are also in the middle of a process, in a project with the OECD on public procurement, and there are also some open cases related with public procurement, to which I cannot refer expressly because we're in the middle of the investigation. But so there's a lot going on. But I would say mainly we are in a transitional period, and that also needs from us a very creative way of working, and as I said, using our brains every day.
And there are some big brains there too. So we have confidence that the reforms will be successful. Oscar, I'd like to turn to you because we don't often have an opportunity to hear about developments in Panama and the competition law and consumer protection issues. So I'd very much welcome your insights on these key developments and your priorities for the agency.
Thank you, Liz. We are currently, our emphasis is in fighting collusion in public procurement, especially in pharmaceutical sectors, the Social Security institution, and in public works. We do not a lot of work in mergers because our regime is a voluntary one, not a compulsory, with the exception of the mobile telecommunication, that there's a recent law that makes the mergers have to request our approval first. In consumer protection, the main goal is to improve the housing sector. We have almost 25% of our claims is related to that sector. We have proposed an amendment to the law that may produce some upgrades for the consumers related with the time they can present and the claims and so on. And as a matter of guidelines, we are currently working in fine guidelines about the amounts we impose after there is a decision at the courts and the procedure to impose at fines.
Thank you for this quick overview of recent developments. I'd like to follow up on some of the reforms that all of you have touched upon, perhaps starting with Pablo and Argentina. As you mentioned, Pablo, Argentina has been undergoing a major antitrust reform, and last year the Argentine Congress adopted a new competition law. Could you please tell us what key changes the reform has brought to the antitrust architecture in Argentina, and also how these changes will affect antitrust enforcement and policy in the country? Also about the progress of the reform, if you could talk a little bit about that. I know it would be of a lot of interest to our listeners.
Sure. As I said, one of the main changes is an institutional change in which we're going from a body that is dependent on the executive power, like our commission, to a more independent authority, decentralized of the government. So that, as I said, also has already started. So we're in the middle of a process. The jury will gather all the candidates, and then we will have the appointments of these candidates. And as I said, by October, we hope to have a new authority in place. As for the other main changes in the law, as you know, the former law was absolutely outdated. So it was, as I said always, and this is a personal opinion, would only not deter, but it was a sort of a formal invitation to collude or to commit anti-competitive conduct. So in that sense, we have increased the deterrence on our current law by increasing significantly the fines. The fines are defined in a new process in the sense of they could be up to 30% of the annual turnover multiplied by the year of the conduct. It could be double the illicit of the illicit gains. And if none of those could be identified, there was a maximum fine of up to 200 million units. Each unit, to give you an idea, is $50. So the maximum fine, if you cannot get those calculations, would be up to $100 million. Apart from fines, we also updated the thresholds on merger control, and we are going from an ex post system in practice to an ex ante or pre-merger control system. And I think it's also one of the main changes because, and again, this is a personal opinion, I think ex post control of mergers is definitely nonsense, in my opinion. So we are going back to normal on this, and also not because as an authority it's very difficult to unscramble the eggs when you're doing an ex post control of mergers, but also the incentives are not there for the parties of the transaction. So the incentives, I think, are going to be in the right place with a new pre-merger control. And last but not least, there is a huge improvement or change on the damages actions sector. This is not only in Latin America, Argentina. It's a problem in all Latin America in the sense of, I think private enforcement has not started yet. So we have had, to give you an idea, Argentina has had some sort of competition law since 1923, and we have only 2 cases. Only one has been resolved and the other is still being under investigation in the judiciary. So we reformed that part of the system in the sense of allowing follow-on actions and standalone actions both. And we also got some changes that, if you want, we can go further on that in order to tackle some of the problems that I think might be suffering now in Europe after the directive on damages, which I think the way in which we resolve those issues might also help us to get more private actions and also create more deterrence in general. And there's also a class action bill being discussed right now in the Congress.
Thank you, Pablo. I'm turning to Oscar now. In Panama, there are some key potential antitrust reforms on the legislative agenda. Oscar, could you please tell us more about these planned reforms?
Yes. The main objective of the reform is to take decisions in a shorter time frame. Currently, we act as a kind of prosecutor, and we have to present suits against those enterprises and the judiciary power. They are taking a lot of time. Some cases are taking up to 10 years to make a decision at the first level, so that is not working well. We are trying to turn our agency not only for investigative, but also for taking the decision, that anyone who wants to review that decision have to go to the Supreme Court. The reform proposal is currently a discussion with the government and with some trade associations, but we are not so positive that we have this before the current government ends in June. So maybe we have to wait to the next government to see what happens. The other reform is related to the fines. Currently in Panama, the maximum amount of fines is only $1 million. So for several enterprises, that amount is really ridiculous. So it's almost an incentive to collude. So we have to try to get in tune with the best practices, maybe establishing amounts related to a percentage of the turnover of the operation. We have to also make some amendments in the leniency program to make it really effective. The leniency program has been in the law in the last 12 years, but we don't have single case yet.
Wow, that raises a lot of food for thought and maybe for a few questions too. But I can't help but follow up on Pablo's statement that without pre-merger notification, merger control is somewhat nonsense. So maybe I can turn to challenges, maybe including in the post-merger notification area, to Oscar. And just, you had mentioned a few: leniency, the fines being limited. Are there other elements that you would like to tell our listeners about that you're finding a challenge in Panama?
Yes, indeed, we have identified that the issue that we cannot give penal or civil immunity is maybe one of the main reasons for that. We have talked with the general prosecutor about this, but we have to make reforms to the law in order to give up the power to bring those immunity.
Just following up on leniency, I think this issue has come up before as part of our discussion. Alexandre, you mentioned, cartel enforcement and CADE's robust cartel enforcement program. In addition, CADE now has 15 years of experience using its leniency program, which over the years has been refined and fine-tuned a number of times. Could you tell us about some of the recent Brazilian developments with regard to applying your leniency program?
Papai, let me tell you one thing that is very important in Brazil. The leniency program is very consolidated right now. So you have 15 years of experience. And one thing that is very important in a leniency program is predictability. This is important. And we have to preserve the golden rule. So Brazil is going in another direction from the rest of the world. If you see United States, Europe, and other countries, the leniency is going down. In Brazil, it's going up. One is because of Lava Jato case, the car washing case. Our numbers is impressive. If you see how many leniency we did in 2016, 2017, and 2018, if you put everything together, it's gonna be around 80 leniencies. So right now, I have kind of 28 markers that we are negotiating. So leniency is very important to discover cartels, because cartels is a kind of conduct that you don't see the material proofs. So nobody sign a contract of cartel. You have to be someone inside of the organization to tell the history of the cartel and what happens. So in Brazil, we do leniency. We sign the leniency just with the first in. It doesn't mean that the second in, the third in, or the fourth in, we're not going to do any settlement with them. So we do another kind of settlement that calls cease and desist settlement. And what is the difference of the leniency and the cease and desist settlement? Is the structure of incentives. In Brazil, the leniency applicant has totally immunity of the administrative sanctions and also to the criminal sanctions. But the second one, the third one, who is signing the cease and desist settlement, they don't have criminal immunity, but they have up to 50% of discount. So this is a big difference of both settlement. And the convergence is all of them have to collaborate. So for the government, the important thing is stop the conduct and get evidences that so after that we can have a case and goes on with the procedures.
Pablo, I understand Argentina has a new leniency regime. What can you tell us about it?
Yes, indeed. One of the reforms, the important reforms of the new act, is that we are introducing a leniency program. We are following some similar leniency programs around the globe. The first to come will get a total immunity. The second and the next ones may get between 50 and 20% reduction on the fine. We have also introducing a leniency plus program in the sense of if you cannot get on the first conduct, but you can also identify another conduct, you can get also a benefit. The immunity or reduction of the fines is covering not only fines, administrative fines, but also criminal fines and damages. And right now, what we've done last year, once we got the act, we drafted some procedural rules for leniency applications, which were sent. Right now, they're under revision in the ministry and the permanent legal service of the ministry. And we hope we may have these procedural rules of leniency out soon, because they're very, very important. And following my friend Alexandre's words, we need predictability here. And although we have, for example, the leniency program in the Act, we have not received any application yet. So we need those rules to get out soon in order to get that predictability and to guarantee confidentiality issues, et cetera. So until we don't have that, we don't expect to have any applications. But if we receive them, we have to deal with them.
Perhaps the two jurisdictions of Argentina and Brazil will serve as models for agencies that are still experiencing issues with leniency, like Panama. Just turning back to Pablo for a moment, you've spoken eloquently on the substantive changes that we're in for with the new law. I was wondering, kind of picking up on the procedural point with respect to leniency, are there other procedural elements or issues that you're looking at in Argentina?
Good question, Liz. Yeah, definitely. We have had some very substantial changes with the new acts. As I said, we had worked a lot on these procedural rules for for leniency. We are also issuing a lot of guidelines on the merger side and also on conducts. Last year we issued guidelines on unilateral conducts. But I think it's also very important to stress that sometimes you don't only need a clear and very beautiful law, but you also need some specific rules of internal proceeding and those types of rules that allow the authority to work in a very specific and proficient way. So sometimes, as I say always, sometimes the devil is in the details. So you may have a very nice law, but the application and the enforcement of the law is not the best. As good as that would be your policy. So I think in Argentina although we're going through very important and significant changes, I think the main issue here is that we are going in a path in which antitrust and competition law needs to be a public policy. So once we got the new authority in place with this new act, a new authority that would be independent, and with this substantial and also procedural rules in place, I think we will finally reach a situation of a public policy in antitrust in Argentina. I think it's absolutely necessary. And also, we cannot forget that in Argentina, competition enforcement has some constitutional status. So in that sense, I think those procedural rules of proceeding or internal rules of proceeding are very, very important for this and any authority in the future.
Alexandre? CADE has recently issued several guidelines on mergers last year, the merger remedies guidelines, for example. What can you tell us about recent practice at CADE with merger control?
So CADE has also been very active in merger control. It's always a priority because we have the system of pre-merger notification since the new law in 2012. And this changed completely the way that we analyze the cases. So we have 240 days to analyze the case, but our average is actually 28 days. And if you are talking about fast track, it is 13 days. Some cases we can reach up to 240 because it's so complex, so huge, so we need more investigations. So we have our guideline, horizontal merge guideline. Is very consolidated as well, with 5 clear steps how to analyze the merger. Define relevant market. The second one is the size of the company, the market share. The third one is probability to use the market power. The fourth step is buying power. And the fifth one is efficiency. So, but last year, at the end of the year, we also launched our guidelines of remedies. And this is one big thing as well, because over there in that guidelines, we define what it is remedy. We also point what kind of remedy we really like it, which one is very efficient or not. So over there, you're going to see that Brazil doesn't like behavior remedy because this costs a lot to monitor, that to do the following this and see if it's working or not. And structural remedy is much more efficient and you do it right away. We also talk about how to implement the remedy, the time to do it. We talk about the process to choose who's going to buy or not the assets. And all the things is in this guideline. So give us a lot of predictability as well. And also put the companies in a safe harbor to know what CADE is doing in each of the case.
Well, it looks like we have reached the end of our program. We would like to thank our guests for joining us today. If our listeners have any questions or wish to follow up with you, how can they reach you? Oscar?
You can email me at ogarciac@acodeco.gov.pa.
Thank you. Pablo?
You can also reach me to my email at ptruccion.org.r. That's my email at the Commission, or you can call us or you can find us on the web at the Comisión Nacional de Defensa de la Competencia.
Thank you, Pablo. And Alexandre?
You can find my contacts and can reach me getting the CADE website. So CADE.
This concludes another podcast with the ABA section of Antitrust. If you like what you heard, please join us in person at some of our upcoming conferences. Details about our conferences are available at mbar.org/antitrust. Your hosts today were Krisztian Katona,
Elizabeth Kraus,
Kail Jethmalani.
Until next time, and thank you for listening.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.